Well, let's try to get some insights right now from two legal scholars. J. Michael Luttig is a retired federal appellate judge and prominent conservative who co-wrote an influential article arguing that Trump is disqualified from returning to office because of this amendment to the U.S. Constitution. Also with us, Jeffrey Rosen. He's a professor at George Washington University Law School and president and CEO of the National Constitution Center. Thanks so much to both of you for joining us. So let's start by just reading what we're all talking about here. The 14th Amendment to the U.S. Constitution, which says, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability." Jeffrey, a lot of people expect that the justices on the U.S. Supreme Court will be looking for an off-ramp to try to avoid this question entirely. For example, saying that Congress needs to act first, or arguing that the president isn't included under the 14th Amendment because he isn't expressly mentioned. In your view, is there a way to do that?
As you say, there are off-ramps, and you mentioned two of them. The first one is that the justices might hold that the President of the United States is not an officer of the United States under Section 3. The second off-ramp is they might hold that Congress has to enforce Section 3, that states and courts can't enforce it on their own. The third is they might hold that January 6th was not an insurrection, or they could hold that President Trump didn't engage in it, that his speech was somehow protected under the First Amendment. It's such a complicated mix of constitutional, pragmatic, and political considerations. Remember, Bush v. Gore ended up being decided on grounds that were completely different than the ones that it was originally argued on. So literally anything could happen. As viewers listen to these historic arguments today, listen to all those off-ramps, see which justices are interested in which arguments in particular, and we'll see at the end of this morning whether any consensus seems to be converging or whether we're just going to have to wait until the court's decision.